Wendy is an impact litigator specializing in women's and constitutional rights, and she's going to tell us about the recent legal changes in the USA, of which very kindly Anne did a sort of introduction. So over to you, Wendy, and thank you very much for both Anne and Wendy for all the activism you're doing in such difficult times in the US. Over to you.
Thank you. Thanks so much. Yes, Anne, thank you because you did a wonderful big picture view of so many different issues. But I would like to focus first and foremost on just the nature of sex as a class. And I try really hard to describe it as women as a class. I realize sex is a legal word that describes women, but I prefer to use the word women, and I'll explain why. It's just that sex opens up space for people who are not women. So I really like to just use the word women and also then take control over its meaning, which is problematic for a host of reasons. But sex, I think, more objectively lends itself to other classes and categories, whereas women really do need to have their own space under the word woman, and I'll explain why. I'm going to go back in time to give people the historical story, a short version of it, about how women have been struggling for basic legal equality in the United States for a very long time. It is somewhat parallel to what's going on in other countries. I am not a comparative legal scholar by any means, so I can't answer questions about, well, how does the world work differently, under this regime or that regime, or this law or that law. I'm a little bit familiar with some of the European regimes in terms of how their legal structure is based and where the problems lie. But what I want to say at the outset is obfuscating women's existence is not just a transgender problem. We have been obfuscated out of existence for a very long time. And one of the biggest problems in terms of how it happens to us is the intentional government state-driven plan to separate women from the idea of class. People can be a class, but not women. So much so that when I have filed briefs in my life over the years, again, I specialize in representing women as a class. And when I put that phrase in my briefs, women as a class, my opponent will often cite me back and then put the word sick next to it, as if there is a legitimate objection to the concept of women being a class. My focus as a legal scholar and litigator is to constantly force people to hear that phrase and say it. Wherever there is a conversation about class, I stick in the word woman or women. And I'm particularly annoyed with some of the LGBTQ new activism that has sliced off the TQ and said, here we are, we just want to be LGB, and there's a big celebration about that. Well, that's fine, except where's the W? We even get erased by our friends. The concept of W being a class needs space. And in my opinion, it needs an acronym in anybody's list that claims to care about women. The LGB community, which sided with women, worked with women, fought with women, claimed to be advancing women's rights and sex-based rights in a variety of places around the world, somehow decided that the W didn't matter once that decision came down in the UK, for example, and made clear that there is a biological sex and gender is a construct. The idea that we were once working together to maintain this concept of femaleness, and that somehow that's not worthy of a letter in the acronym, that bothers me. I want to put that out there because it's a newish issue. Now I'm going to go back to give you the history that I promised about the United States struggle for sex equality. And I'm going to probably use the word woman more than sex. It has nothing to do with, I know this is a sex-based rights meeting, but again, I like the word women for a reason, and I'm going to tell you why right now. The history of America in terms of women's rights goes back to when England came over and colonized us as part of England's empire. And what that did for us in terms of the law is it delivered us the British common law, which at the time was pretty explicit that women were not persons of their own right. They were owned by their fathers or their husbands. They never had personhood, so to speak. Therefore, they never had existence, much less rights. That was delivered to us with the colonial era. Then, of course, we decided we wanted our own country. There was a war. You all know, most of you know about that. We become the United States of America, but the formulation of our Constitution was already filled with this baked-in notion of women having no existence. And nonetheless, pretty early on in our nation, women were mobilizing together as women to fight for basic rights, to fight for personhood, to fight for existence under the law. Our Constitution was established in 1789 and then quickly modified a couple of years later to add the Bill of Rights. Our Bill of Rights includes one thing we've talked a lot about already with Anne, which is the First Amendment. It came first for a reason. Freedom of speech is the predominant right and important freedom, because without it, you just cannot have a democracy. So it came first. The Bill of Rights includes 10 amendments to the Constitution, and that was considered basically our foundational legal document for this country. Again, 1791 was that date when we got the Constitution plus the 10 amendments. Well, women still didn't have legal existence. Flash ahead, we then have our own civil war because we have a big fight about slavery, which was actually a fight about money, as most things are. And we end the Civil War and begin to abolish slavery in the mid-1800s, and ultimately try to repair our country by adding some more amendments. The Reconstruction Amendments, as they're known, included the 13th, 14th, and 15th Amendments. Those were meant to bring our country together and abolish slavery. The 13th Amendment abolished slavery for all people based on race. The 14th Amendment created due process rights and equal protection rights for persons. It also gave voting rights to white men. The 15th Amendment gave voting rights to Black men. You see where we're going here? Women aren't in the picture, and for the first time ever, the word male appears in our Constitution, which by definition excludes one category and one category only: female. Women were somewhat happy that the 14th Amendment, this is 1868, the 14th Amendment included the language equal protection of the laws for persons, because women said, we're persons, right? Of course, we have equal protection rights, right? They didn't say equal protection rights for male persons. The amendment said equal protection rights for persons. So women immediately went to court and started enforcing their equal protection rights. That was a very quick flop for women. Every case they filed, and there were two key cases in the aftermath of 1868, but before 1900, they filed two key cases that went very quickly to the Supreme Court, both of which raised equal protection questions or concerns. And in both cases, the Supreme Court of the United States rejected even the claims, which is to say, rejected the idea that women could even call themselves persons under the Equal Protection Clause. They did let us be described as citizens. So we had citizenship rights, but citizens aren't persons. So we quickly went from happy that we were now going to have equality to absolutely devastated that we were not even persons. Immediately we decided we needed to fight for two things, because it was clear we didn't get the vote. That was explicit. Males had the vote, not females, not Black females, not white, not any females. So we decided right away to fight for two things. First, the vote, because we needed that to then develop political power to then fight for equality. It took us a long time to win the vote. We didn't get it until 1920, which I know is somewhat on par with the timing of some of Western Europe's suffrage fights and the timing of when women won the vote there. So that wasn't an accident. There was a lot of similarity and remains a lot of similarity in terms of how we continue to oppress women today, but I'll get to that. We win the vote in 1920 and then immediately file the Equal Rights Amendment, because this was the plan. We knew exactly what we needed to do: win the vote and then immediately use our voting power to win equality. 1923 was the first time we filed the Equal Rights Amendment, and it went nowhere fast. And I mean nowhere. If you look for an answer to the question, why did it go nowhere? Why didn't women use the steam they had generated to continue to succeed and now amass their unbelievable new political power? Half the country were females. We now had the vote. Why weren't we mobilizing the vote together? Why weren't we working together in unity to demand the vote with all of our newfound power? The answer is most women's groups, even by that time, were corrupted, were being managed by moneyed interests that inhibited them from uniting as women. Now, I want to say one quick thing about the ERA that was filed in 1923. The language of it said, I'm paraphrasing, men and women in the United States shall have equal rights. Why did we say men and women? Because only women were excluded. We wanted to fill in the hole. That changed in 1943 when the ERA language, because we had to keep refiling it, so the language changed in 1943. Under pressure, women said, okay, fine, we'll use the language that was used for the 19th Amendment when we won the right to vote in 1920, which described the people who now had the right to vote as people based on sex. I think that was the creation of a big problem for our fight for equality. Women, not sex, had been denied the right to vote in the late 1800s when the 14th and 15th Amendments were adopted. Why did we use the word sex to establish our right to vote? We should have used the word woman. We should have used the word female. We didn't. That began the problem, and in my opinion, opened the door to the obfuscation we're still dealing with today around what exactly is this category. So the ERA gets refiled in the 1940s and goes nowhere because neither party supported women's equality. To this day, neither party supports women's equality. If you're wondering why, it's because there's an incredible amount of money opposed to women's basic legal equality globally, not just in the United States, globally. I ran some numbers a couple of years ago. The cost of abolishing slavery in today's dollar, abolishing Black slavery in the United States in today's dollar, would be around 13 or 14 billion dollars a year. The cost of giving women full legal equality in the United States would run corporate wealth to the tune of about 4 trillion a year. I mean, that's what we're talking about. Now, you were thinking, what do you mean money? What money is being lost? Aside from simply the ability to not pay women equally, which is a big chunk of it, there is just the straight up industry or collection of industries that make a fortune from the capacity to oppress and harm women for cash. You all know what I'm talking about. It's porn, it's sex trafficking, it's prostitution. These are the Black industries that thrive on women's subjugation because it makes harming them as a class of people legal when you couldn't do it to another class and get away with it, not to the tune of the same dollar value that is earned literally on the backs of women's of violence against women as depicted in videos or just practiced in real world terms. So that's an enormous amount of money. We're talking about hundreds of billions of dollars, and it funds both political parties. That's why neither party supports women's equality. They get paid not to, period. Okay, what happened to the ERA moving forward? We got to the 1960s and things started to happen because that was our civil rights era. The rising up of people and demanding certain basic rights, covered lots of categories. There was a lot going on in this country in terms of uprising, and women were part of that. And we wanted just two things. We wanted equality under the Constitution. We wanted Congress to pass the ERA, and we wanted equality under civil rights laws. Civil rights laws at that time gave categories of people equality in particular contexts, like education, employment and in federally funded spaces. Women just wanted to be added to those laws because we weren't there. Those laws then protected, these were the categories that were recognized not only for civil rights laws, but also for 14th Amendment class purposes: race, religion, ethnicity, national origin, and color. I mean, I'm not sure why there was a difference between race and color, but there was, and clearly not in the categories of worthy of protection as a class was the word woman. We did at one point get protection only for employment purposes, but because we didn't have equal protection of the laws, including employment laws, our status under the Employment Civil Rights Statute, even in the 60s, was subject to unequal enforcement in the courts. So if you thought you had civil rights protections in employment and then you weren't paid equally or you weren't treated equally and you went to court to fight about it, the court would be free to enforce your civil rights laws that purport to give you equal treatment for employment purposes. The court could enforce those rights differently and worse because you were female. Why? Because the Constitution didn't give you equal enforcement rights. You didn't give you equal protection rights. So the courts were free to unequally protect you. That remains true today for women in all aspects of life. Without equality, all laws can be unequally enforced. All laws, including, remember what we started with, the First Amendment. Yes, it looks like it applies to us because we seem to think we have free speech, but for women, the enforcement of the First Amendment is subject to inequality when you go to court to say, my First Amendment rights have been violated. Courts have the power to enforce your free speech rights unequally. Courts also have the power to enforce all your rights unequally, including like rights against slavery. This is why sex trafficking disproportionately happens to women. It's a form of slavery, but since women don't have full equal protection against any laws, even laws against slavery, they can be enslaved at a higher rate than other people because it's less illegal to enslave women until the ERA is in the Constitution. This is why when someone says to me, what rights do men have that women don't have? I always say back, and I hope you will too, that's the wrong question. The question is not what rights do men have that women don't have, it's what rights and laws must, as a constitutional matter, be enforced equally when applied to women? The answer to that question is none, zero, nothing. No law must be applied equally to women. That's how important the Equal Rights Amendment is. It applies to everything. Okay, so flash ahead, we finally get to 1972 when the Equal Rights Amendment gets through Congress. By this time, it doesn't use the word equal rights. It doesn't use the phrase equal rights between men and women. It now says equality of rights based on sex shall not be denied or abridged, blah, 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 blah. So now we're in a based on sex, categorically speaking, based on sex description of what the equal rights problem is in the United States. And again, you know, when you think about it now, it's already watered down to include men because men are a sex. But men didn't need equal rights. So what were we doing using the word sex? Really important to think about this because that was done maliciously. But it is what it is. It's what we have. It quickly went through Congress only after both parties agreed to tack on a 7-year deadline for ratification in the states. For those of you who don't know, we amend our Constitution under Article 5. In other words, this is the rule. Article 5 is the rule that teaches us how to amend our Constitution. It says we only need two things. Congress has to vote for an amendment by 2/3, and then it has to be ratified by 3/4 of the states, which under what we have now is 50 states, so the number would be 38. And that's what we had back in 72. So 72, Congress passes the ERA, it goes to the states for ratification. It quickly makes its way through 20 some odd states, and then it grinds to a halt. And it just never gets to 38 states by the deadline. The 7-year deadline gets extended to 10 at one point. It still never gets to 38. We make it all the way to 35. The deadline expires. Women kind of give up. A small group of women didn't give up. They said, that deadline is a bunch of bullshit. We're not going to have a deadline. I mean, that's silly. Other amendments didn't have deadlines. Well, things got really heated in 1992. So the deadline expired in 82. And we were a little bit, unclear what should we do until 1992, because in 1992, the United States adopted the 27th Amendment, which pertains to the timing of congressional pay raises. And women became incensed. Why? Because the 27th Amendment was given 203 years to ratify. It passed Congress in 1789. It didn't pass three-fourths of the states until 1992. And women said, wait a minute, you can't not expect us to tolerate such disparity in the amount of time states have to validate. Oh, do I have 5? Oh, 5 minutes. Okay. So, women started to rise up. And we said, we're not going to start over. We're going to go get the last 3 states that we need. And then we're going to go to court and argue we ratified the ERA within the time limit, because you can't have a time limit, because you didn't give that amendment a time limit. So you can't do it to us. That's an arbitrary way to run a country. You're not going to get away with it. We got the 3 states to ratify. That happened in 2020. I filed a lawsuit because right when the last state ratified, the Trump administration was in power. They blocked the ERA from being added to the Constitution. I filed a lawsuit. Another lawsuit was filed after mine. Both of them were still cooking, if you will, when Biden took over in a year later. And then the Biden administration had said during the campaign, we love women, we support the ERA, vote for us. So a lot of women voted for Biden and Kamala Harris, and then they blocked the ERA too, and made the same legal arguments in briefs in my case and the other case that the Trump administration had made. This was a really important moment for women in our fight for equality in terms of the history, where we've been, where we're going, where we need to move forward now. We really learned deeply that there is no hope that either party will ever support women as a class, much less women's equality as a class. And in my opinion, the only remedy is for women to unite as women, to center their suffering as women, to hold tight to the concept of womanhood, and to reject any efforts to water down who we are as a people, because the only thing we need is political power from our femaleness. Yes, we are also other things. We might be gay, we might be Black, we might be disabled. If we can choose to come together across all lines, unite as women, fight as women, demand our class power as women, we will rule the world, because we make up over 50% of the population in almost every country. We need to unite to use that power to not only establish our equality, but to then fight for all the other things we want and need. Equality first, everything else will come second.
Thank you very much, Wendy. That was fantastic. There are lots of supportive comments on the chat. Even someone has said that you have many TED Talks that you have been talking about this issue. So it would be very interesting to have a look at that. Oh, sorry. Let me add myself.
Can I just say, I do have a TED Talk, but I also have a law review article. I'll send that in the chat.
Please do, because there are other lawyers in the chat, and also we're saying that this was sadly too condensed to really understand all the legal comments and all the legal motivation that you were saying, because we understand this is a matter of legal technique. And not being a lawyer, many of us, and being from other countries where the legal status is different, we have to understand the historical and the legal context from where you're talking. So this was very, very interesting. Thank you very much.